Commissioner Eskovitz, are you there?
Here.
Commissioner Wasserman,
Here.
Commissioner Nguyen,
Here.
Chair Remke.
Here. Okay, thank you. Welcome. Just before we get started, I wanted to give a quick thank you to the staff. As everyone knows, we just finished up with the election season and everyone worked incredibly hard. You're going to hear about some of that today, but I just want to acknowledge that and thank the staff. Okay, so item 1, is there any public comment regarding something that is not on the agenda? Okay, seeing none, we will get started. First, we have the committee meeting minutes from October. Are there any comments or corrections?
Nope.
Commissioners on the phone? Anything on the minutes from October?
I have one question here.
Okay. I'm sorry, can you hear him?
21, 108, opinion request.
Item 108.
I'm confused what's happening. Oh, okay, go ahead, Commissioner Wasserman.
Okay. I'm asked.
Commissioner Wasserman, can you call back?
Commissioner Wasserman, we're having trouble hearing you. The phone keeps.
There we go.
Think he's gone?
I think he's on his way to call back. So we'll sit tight. Will we hear a buzz or something when he comes back on the line?
Yes.
It's just a time to get to know your neighbor. Does anyone have his number? Go call him. What do you think, John?
Commissioner Eskovitz, are you still there?
I am, yes.
We're just waiting on Commissioner Wasserman to call back.
I'm just testing.
Ask if he's here. Go.
Commissioner Wasserman, are you there?
I was just testing. It's fine.
Pat, are you there?
This is Gavin Wasserman, apparently. Now I'm let back in.
Okay. Hello, Commissioner. We're glad you're back. So we're going to get started again. And Commissioner Eskovitz, you are still on, correct?
I am, yes.
Okay. Sorry for the delay, everyone. Oh, and Commissioner Wasserman, you were discussing on the minutes number 108. Go ahead.
Second paragraph, last sentence, beginning with Commissioner Wasserman, ending with California law. Rather than tinker with that, just strike it.
Okay. Okay, anything else on the minutes? Okay, I move
I
to
have
approve the
nothing further.
minutes as amended.
And I'll second.
Commissioner Kasher?
Yes.
Commissioner Eskovitz?
Yes.
Commissioner Wasserman?
Yes.
Commissioner Nguyen?
Yes.
Chair Rumke?
Yes. Okay, we will move on to the consent calendar, which is includes items 3 through 48 I'll just note that the agenda says 3 through 47, but it's 3 through 48. And would a commissioner like to take anything off the consent for purposes of voting, not for purposes of asking questions? Obviously, we'll have that opportunity.
Yes, it's Commissioner Eskovitz. Out of an abundance of caution, I will not participate in consideration of 5, 9, or 30.
Oh.
So I'd have to have those removed from the consent calendar.
They are so removed. Anybody else? Okay. As to the remaining items, do the commissioners have any questions or comments for Gary?
I have a question on item 10. Can I go ahead and start?
Yes, please.
So this is a default decision. There are 6 counts, 6 reports that have not been filed to date. She's been contacted, I think, 30 times and has not been willing to, kind of engage in a settlement. And I'm just surprised penalty is not the maximum penalty. So I would like to just open that up for discussion. I would be inclined to, impose this $12,000 fine for some very limited duration to see if we could get those reports filed. And, maybe 3 weeks, a month later, if the reports are not filed, we go ahead and impose the maximum fee. But I'd love to hear from Gary on this. Thank you.
Good morning, Madam Chair, Commissioners. Gary Winnick, Chief of Enforcement. I appreciate your comments. I think what we were looking at in the default, everything you're saying about the context obviously is very true. We did, in some of our communications, excuse me, with the respondent, receive some of the campaign bank accounts. So we do have some information that the activity was low, which is, I think, why we initially brought it at that dollar amount. But I completely understand your point. The only other thing I'll throw in is, much as we discussed with some of the SEIs, our plan for non-filers going forward after a default is to request the initiation of civil litigation to compel compliance with the statement. Obviously, I need approval for that, but that's our plan going forward as well.
Anything else on that one?
No, thank you.
Okay. Any other questions?
Yeah, I had a question on number 3. And my question relates to counts 3 through 5, where there were contributions that were made in excess of the contribution limits. And my question is whether or not the individual candidates who receive the contributions are being asked to disgorge those funds and return those funds in excess of the contribution limits.
Sure, thank you, Commissioner. They will be, I guess, if the stipulation is approved. Generally, the way we do that, obviously, is we have the finding that the contribution was over the limit. And I believe, yeah, it's 85-301. So that would make it subject to the disgorgement under that section.
Great. And just a follow-up question, procedurally, how do we go about that? Is there a letter that's sent and kind of what's the timing on that?
The timing on that is once we process, after, this is probably more than you want to know, but after we close the case, we send a letter obviously saying your case was closed, here it is. And then it's at that trigger point that that the letter is sent. And I'm sorry, I'm hesitating only because I think the actual violation for that was, I'm sorry, I think I need to actually retract my statement on that. The disgorgement is only subject to the money laundering section, which is 84-301. Okay. So sorry, I was reading quickly while I was talking to you, but that actually, the contribution over the limit would not subject it to disgorgement under that statute. So I apologize. Let me reverse my answer.
Okay, that works.
Wait, so are we talking, I'm confused now.
I'm sorry, I confused it.
85-301 versus 85-302?
84-301 is actually the section subject to disgorgement, which confused me momentarily, but my brain is working now. So that section is not actually subject to disgorgement. It's very limited to basically not disclosing the true source of the contribution, which is 84-301. So my apologies.
Mr. Winnick?
Yes, sir.
Commissioner Wasserman, your phone line is still not working that great. Are you still there, Commissioner Wasserman?
And Commissioner Eskovitz, you are still there, correct?
I am, yes.
Okay, we're going to continue with the discussion for the consent items at this point because I don't think we can continue to delay this. But hopefully,
And you,
oh, you're back? Are you here all along?
yes.
Okay, we're just having a lot of trouble with your phone, so we'll have to keep
Yeah.
telling you when we can't hear you.
I'm relocating to another position. I never had trouble with this before, but that doesn't change the fact. The only thing I had to follow up on that was Mr. Winnick indicated that disgorgement doesn't apply in the situation where they're over limit contribution, but the over limit amounts are disposed of how?
Under the statute, it's not required that anything be done with those. Generally, we've asked people to return them to the contributor. But that's our policy. That's not found in, well, I suppose if you look at it as you may only receive a contribution up to that limit, the statute does indeed say that you can't receive that money. So if you look at it that way, but generally we do ask people to return it. So I apologize for the initial confusion, but that's
But
where
so
we're
we
at.
will be
Right.
asking them to
The
return
different-
it. I'm just confused.
Yes, that's correct. I'm sorry for causing the confusion.
Right.
It's not
So the
subject to
difference
disgorgement. It
being-
is subject to return to the original contributor. And that's sort of our reading of the statute where you can't accept under the law contribution over that limit.
Got it.
Mr. Winnick, is that required by the stipulation?
It is not required by the stipulation, although generally we seek that as part of the compliance, but this will be sought afterwards. This is actually making the contribution over the limit, so the person who received it is going to have to return it.
Right, back to the contributor as opposed to disgorgement, which goes to the general fund.
There won't be a disgorgement to the general fund, it'll be a return to the original contributor. In this particular case, a lot of times if you receive a contribution over limit, we'll also initiate a case, but I think here the respondents needed to do the calculation to determine whether or not they're over the limit. So it wasn't necessarily information that was in the control of the person who received it. So for that reason, we didn't proceed against the person who received it. So it's a little bit of a unusual situation.
Thank you.
Okay, any more questions on number 3? All right. I would like to just bring up item 9 for a moment. No. Oh, sorry, I'll hold. Thank you. I'll hold off on my comments. Anything else regarding the consent calendar? Okay, is there any public comment for an item on the consent calendar? All right, seeing none.
So I'll move to approve, I'll move to approve items 3 through 48, removing 5, 9, and 30.
I'll second.
Commissioner Kasher,
Yes.
Commissioner Eskovitz,
Yes.
Commissioner Wasserman,
Yes.
Commissioner Wynn,
Yes.
Chair Remke.
Yes. Okay. So now going through each item that has been pulled, starting with item 5. Are there any questions or comments regarding item 5 from the commissioners?
No.
No.
Okay, any public comment regarding item 5? Okay, I will move to approve item 5.
Second?
Commissioner Kasher,
Yes.
Commissioner Wasserman,
Yes.
Commissioner Wynn,
Yes.
Chair Remke.
Yes. Okay, so item 5 is approved. Then we'll jump to item 9. And I just wanted to pause and comment, and I believe you saw the letter we received, which had some strong criticism regarding the stipulation. So I just didn't want to jump over that. I think I would just frame the question in the simplest way, or my understanding of the concern or complaint has a lot to do with why the candidate was not named in the stipulation.
Right.
So if you can address that concern.
Sure. Thank you, Madam Chair. What we've tried to do, I think, as an overall approach to all our cases is to identify the parties most responsible for the violation and especially where we're seeking a stipulation, try and hold them accountable. I think that's pretty consistent in this case, what we've done with other cases. For example, on our last agenda, we had several money laundering cases, 2 of which were from County of Yolo and County of Santa Clara. In those cases, we didn't hold the candidate himself responsible, even though he did in fact receive laundered funds. I think that's very analogous to the case here. I will point out for interest's sake at least that the person who sent the letter of that represented that party and didn't have much of a complaint when we applied that policy for their own case, but now has a complaint about this. But again, that's generally how we approach the cases and the stipulations. I think obviously it's subject to your direction of how you would like us to proceed on it, but that's our, I guess, our philosophical approach to it.
Well, before we talk about that in the bigger picture, I guess I'm concerned or have the same somewhat concern that was raised in the letter again regarding if there's a certain implication that perhaps we're saying unless the candidate authorized the activity, we're not going to turn to them. But that was not the intention of the stipulation or your position, correct?
No, not at all. I think, you are responsible for the actions of your agents. In the course of the investigation settlement, a lot of the factors we're looking at are, whether there was actual knowledge or not, what your level of cooperation was with the investigation, and sort of looking at it holistically to try and craft a resolution that we think is fair and something we feel comfortable taking to the commission. And that's what we did here. The particular candidate who received it was extremely cooperative. The election in this particular instance happened, there was a candidate who dropped out, and it happened in a 60-day period, so things happened rather rapidly. And then the candidate in this case, the elected official, was extremely cooperative, and there really was no evidence that he had literally anything to do with it. So again, technically, could he be held responsible? Absolutely. But I think we just tried to craft what we felt was a fair and appropriate response with people who had actual culpability.
So then to follow up on the discussion earlier about returning the contributions that were received, how do we handle it in this situation?
This is a slightly different situation for us because we don't really have the ability to enforce local contribution limits. So on a state race, which is what the last case was, that is clearly covered in the act where it lays out the contribution limits for state candidates. For local jurisdictions, we don't really, at least in my opinion, have the authority to enforce their local contribution limits. So really the ball would be in the court of the San Francisco Ethics Commission to address that issue. I don't really feel we have the authority to really do it.
Okay. I guess I would say from my point of view, as far as direction in the future, and I'd be interested in hearing from the other commissioners, I think there is some concern regarding not looking to the candidate as well. And I understand in this case why you didn't and based on the facts. But I guess I would encourage us to look to the candidates as well in these situations in the future.
Sure. And again, I just want to make sure I'm following the direction. So is the direction, regardless of culpability, the candidates should be included?
Well, I guess as you set forth the law and the stipulation, it talks about intentional or negligent acts.
Clearly, they have liability. I just want to bring you back what you'd like to see. So is that sort of a blanket rule? Do you want, you still exercise some discretion, or?
I think, of course, you should still exercise your discretion. And I guess I would find this case perhaps on the fence.
Okay.
Again, I'm comfortable with it from the facts set out, but I would lean towards, when in doubt, to look to the candidate as well. Because, again, of that liability and responsibility, and, again, the concerns raised in the letter.
Yeah, no, I appreciate that. Thank you.
I don't know if the other commissioners. Oh, you turned it off.
Oh, sorry. Yeah, I think the way this was presented, I was comfortable the way this was presented because it looked like staff had, in fact, investigated whether there was a relationship between the committee and the candidate and found that there wasn't a relationship. So I would, at a minimum, want you to encourage, want to encourage you to examine that. And if there is, in fact, a relationship and there's communication, we definitely need to bring the candidate in. But if it really is, in fact, an independent operation, I just think it's harder to include the candidate in these kinds of actions.
Right, but it was the candidate's agent, and that's the problem.
And, if I
And
may
we're
ask-
saying that
sorry.
ultimately it's a candidate-controlled committee is the finding. So I think you have to look to the candidate when you make a finding that it's a candidate-controlled committee. Again, that's my feeling.
Mhm, mhm.
And I think we're really sensitive to the fact too that we don't want to open a loophole where you just sort of say your agent did it, and
Right.
so we are sensitive to that, and I
And
appreciate
I
the
think
point.
that's the biggest issue. Right,
Right.
exactly. Any other commissioner?
This is Gavin Wasserman. If you can hear me,
Yes.
I'm in agreement with the chair on this. Looking at some of the facts in this particular case, I'd probably be the chair treasurer. It's going to be determined as the candidate control committee. So, I share those concerns. Thank you.
Okay, thank you. Any other comment from a commissioner? All right, is there any public comment on this item? Okay, seeing none, I move to approve item number 9.
Second.
Commissioner Kasher,
Yes.
Commissioner Wasserman,
No.
Commissioner Nguyen,
Yes.
Chair Rumke.
Yes.
This motion passes.
Okay, so then we're going to jump to item 30. Are there any comments or questions from the commissioners on item 30?
No.
Okay.
No.
Any comments from the public on item 30? Okay, seeing none, I move to approve item 30.
Second.
Commissioner Kasher,
Yes.
Commissioner Wasserman,
Yes.
Commissioner Nguyen,
Yes.
Chair Rumke.
Yes.
This motion passes.
Okay, so that is the consent calendar, if I'm correct. And then we're going to move to items 49 and 50, and our Chief of Enforcement is going to comment on both of those.
Thank you very much. For item 49, this is a case that is ready to receive an administrative hearing. Is at that stage, and as you know, you have the ability, if two of you wish to hold the hearing and have an administrative law judge participate. It's sort of a affirmative checkoff, if you will. If no one has the desire to do that, then we'll have it assigned out to the Office of Administrative Hearings.
So unless there are any questions or comments on this item, it requires no action, and it will proceed to the ALJ without any motion. Is there any comment or question from the commissioners on this?
Nope.
Commissioner Wasserman, no.
Okay. So, and then item 50?
Thank you, Madam Chair. I wanted to give the Commission just a brief update on our pre-election proactive efforts. We've received a lot of direction to sort of make sure that compliance happens when it's relevant. So the Enforcement Division staff worked extremely hard this election cycle to try and make some of that happen. I'll give you a few quick highlights, and if you have questions, feel free. We targeted some areas where we thought we could make the most difference and be effective. So the first one was ballot measure advertisements. There were 172 state and local ballot measures, if you can believe that, across the state this election cycle. We took a look at all of the video communications, including television ads and online ads, to ensure compliance with the disclosure rules. There were 19 that we identified as having problems significant enough for us to intervene, and every single one actually corrected it really almost immediately. One actually wound up being serious enough to be on the agenda, which was a case that you just approved several moments ago. Second, we targeted pre-election non-filers to avoid being in the default situation after the fact. We obviously can't do every city in the state. We're cost prohibited from doing that due to the size, but we targeted cities with population over 100,000 that do not have their own ethics commission that's sort of watching after this. So I wound up being 51 cities. In those, we had 16 people we had to intervene with. Every single one wound up filing, so we had full disclosure in those cities. One required a little extra nudge of filing some litigation, but saw the light immediately upon receiving notice of our lawsuit, so that was positive. We also took a look. I want to highlight, one of the cases just approved with now Assemblymember David Hadley. We used our AB 800 powers really for the first time. There was a contribution that was received. Again, I don't think it was malicious in intent or anything, but we were able to intervene before the election and have that money returned. It's about $41,000 and make sure, obviously everyone's playing by those rules. After the Arizona case, our staff came up with the good idea, I think, of taking a look at state ballot measure committees for really large contributions and sort of doing a scan to see if there was that type of laundering or lack of disclosure that we can intervene on. I guess the good news is we took a look at a few of them that, we were interested in. Everyone really seemed to have disclosed those properly, which I think is good news and, perhaps reflective of some of the work the commission's done in the past. And last, just a quick, two quick updates. One on the San Bernardino contract. We did continue our pre-election proactive audits as per the contract with 18 different committees. I think those wound up being extremely positive. We identified several issues that got corrected pre-election, which I think made a big difference and helped keep all the disclosure where it should be rather than sort of looking at after the election and audits. I thought that was well received and very positive. You'll probably be seeing some cases coming down the road on those as well. And just lastly, real quick, one of the things I observed when I first got here was the FPPC tended to be used a little bit as a campaign tool where people filed complaints and, we had a tendency to sort of sit on them and then you get your media splash and then nothing comes of it. I've tried really hard since my time here to try and make us not be a tool for that sort of thing. And I took the liberty of tracking some of the numbers this time just to give you a sense of it. In the 60 days leading up to the election, there were 150 complaints that we received in enforcement that we reviewed and rejected before the election. Again, they were great and small, and it's a little bit of a rough number in terms of that particular data set, but it does give you a sense, of the volume that we're working to deal with. Just my own personal observation, I think there were fewer complaints without merit that were filed this season, but that's just sort of an anecdotal observation. So that really is it. I want to give you a quick overview. If you have questions, I'd be happy to answer them.
Any questions? Okay, Commissioner.
I have a comment and a question. The comment is, wow, that is fantastic. Reading this report, in 2.5 pages, you sure pack a wallop. I'm really impressed with the work, you and your staff have done. It's very, very impressive, especially I think the last of complaint rejection. That really kind of is, really a fantastic summary. So thank you for that.
Thank you.
The question I have really is just about the San Bernardino contract.
Sure.
So, it looks like there were 18 proactively audited campaign committees. So the question is, when we've contracted with one, fairly large county and we have a fairly limited staff, do they get kind of more attention or how could you just kind of discuss, and does this kind of set us up to contract with a lot more counties because, you're just staying on top of their elections in a way that, other counties might want?
Sure, and I'll defer to Aaron on some of the issues, but just from an enforcement division staff perspective, if I don't compliment my staff enough, I should. They really are extraordinary people and work really hard. And we've folded this into our existing workload, and we're still able to do, our regular audit cycle, which we're ahead of schedule on, and do our work for the pre-election proactives. Obviously, I think if we were to add additional counties and additional workload at some point, we'd hit the point where that would no longer be possible. But at least for this cycle, we were able to fold it into the existing workload. But, I think Aaron can speak more, but we'll have to decide going forward what that means.
Just by way of background, last year there was a bill going through the legislature that would have allowed us to do work. Specifically, was brought by Senator Correa for Orange County. It didn't make it through to the governor's desk, but it is something we are sort of from time to time approached by different jurisdictions to ask us about. We're always open to talking to them. Gary, this is essentially the second full year of working with San Bernardino, and so we are still kind of in the process of evaluating how much staff time that's taking and measuring that. And internally, we've discussed a lot about, I think there is an economy of scale. We have the operation running, we have the staff that's trained up. So, adding some of those is okay, but kind of what Gary said, if we start to add, we can't necessarily add every jurisdiction. So it's something we're kind of continuing to monitor, and there's some political things going on in the background too. So.
Okay, thank you. Thank you, Gary.
Yeah.
All right, we'll move to items 51 through 53 regarding regulations, starting with item 51 and the Form 700.
Good morning, Commissioners. Linda Cassidy, Chief of the Technical Assistance Division. My presentation is short and sweet this morning. As my memorandum notes, the Form 700 and accompanied documents have been updated for the next filing season. There were no statutory changes this year. And of course, we will update the gift limits following the regulation adoption. I have not received any additional comments since publication of the draft forms before you, and so I ask for your approval.
Any questions from the commissioners?
Nope.
Okay, is there any public comment on item 51? Okay, seeing none.
I move approval of item 50.
51.
51.
I'll second.
Commissioner Kasher,
Yes.
Commissioner Eskovitz,
Yes.
Commissioner Wasserman,
I'm sorry, that was 50.1, right?
51.
I guess the memo, the version, agenda version I have says 50.1, but I know what we're talking about, and so yes.
Commissioner Nguyen,
Yes.
Chair Remke.
Yes,
Thank you.
thank you.
Excellent.
Okay, item 52 regarding the cost of living adjustments to contribution limits, voluntary expenditure ceilings, and gift limit. And I believe everyone, all the commissioners received the latest hot off the presses updates on the numbers, which we'll talk about. And there have been copies made available for the public and posted online as well. And go ahead and maybe you can explain to us what happened here.
Yes, good morning, Chairman Remke and Commissioners. I'm Emmeline Rodriguez, Commission Counsel, and I'm here to present for adoption the proposed amendments to Regulations 18545, 18703.4, 18730, and 18940.2. And these are regulations that deal with the contribution limits, the voluntary expenditure ceiling amounts, office holder accounts, and gift limits. The Act requires that these limits be adjusted in January of every odd-numbered year to reflect any changes in the annual average California Consumer Price Index. As you can see, that there are some last-minute changes from Department of Finance with regard to their figures. They gave us a call late yesterday, and we had to revise some of the figures. These appear in the materials before you, and they're highlighted. The gift limit remains unchanged. However, there are some slight changes to some of the campaign contribution limits, voluntary expenditure ceiling amounts, and office holder account limits. They have decreased slightly from our last projections, which used September 2014 CPI figures. However, the overall amounts for these limits have increased from the prior 2-year period. And we recommend that the Commission approve these proposed amendments.
Okay, any questions, commissioners? Is there any public comment regarding item 52? Okay, I do not see any. I move to adopt item 52.
I'll second.
Commissioner Kasher,
Yes.
Commissioner Eskovitz,
Yes.
Commissioner Wasserman,
Yes.
Commissioner Nguyen,
Yes.
Chair Remke.
Yes,
This motion passes.
thank you. Okay, item 53 regarding the conflicts of interest, determining the materiality financial effect of a decision on a business entity.
Good morning, Chair Remke and Commissioners. I'm Bill Lenke with the Legal Division. This item continues the process of reorganizing the Act's conflict of interest regulations. The reorganization plan was presented to the Commission at the April 2013 meeting, along with an extensive memo explaining the background of conflict of interest laws and the way we've treated the application of the Act's conflict of interest laws over the years. The original plan was to be able to find an approach that would enable staff to give meaningful advice. Too many of our letters went for way too long, 10 pages plus, outlining the whole system without coming up with a definitive answer. And staff believed that one of the reasons for that was there were too many numbers, too many counting, too many fixed determinations, and most of those were impossible to tell. In June, we presented a conceptual plan for getting away from measurements and counting and getting more back to the original way conflicts were determined, looked at, and analyzed under a reasonable person approach. And conceptually, that was approved for the real property regulation in June of 2013. And in, I believe, April of this year, that plan was instituted for real property. This proposed amendment now continues along that same path for business entity interests. With that, if there are any questions, I'd also like to acknowledge that we got a letter from the California League of City Attorneys, and Mr. Mason is here to address those issues.
Commissioners, any questions? Okay, is there any public comment on? Yes.
Here, Remke, members of the commission, thank you, and staff, thank you. My name is Sean Mason. I'm the city attorney for the city of San Mateo and chair of the California City Attorney's Department FPPC committee. I have submitted a letter, as Mr. Lenkeit indicated, on the proposed regulation and would like to address my comments this morning to 3 points. First, our committee is concerned about staff's recommendation to eliminate the dollar thresholds that are in the regulations. Second, the elimination of an important exception to purchases by large corporations. And third, the language used to describe factors to be considered in determining whether impacts on businesses indirectly involved in the decision will be considered material. So moving to the first point, the elimination of the sliding scale for dollar impacts. When we as city attorneys review proposed amendments to the regulation, I'd like to sort of explain the lens through which we look at those regulations and proposals. And we're looking at them from the perspective of being able to have confidence in our ability to give the right answer when we're asked a question. Because we are the people who are on the front lines. We're the people who get the questions from local officials, whether they're appointed or elected or staff. They come to us and they ask us whether they can participate or not. And so we really, when we look at these proposals, want to make sure that we know what they mean and that we can then tell the particular public officials what they mean in a given fact situation. And so that's sort of our perspective when we look at proposals to change regulations. And the committee's sense was this particular change did not increase our confidence level if it's adopted, and in fact would decrease and reduce our confidence level.
But what about staff's comments or concerns who also experience and have to give advice on these exact issues, basically how impractical it really is under the current system? Because I know you use the term bright line because at the end of the game, there are some numbers. But the problem is leading up to those numbers, you're making a lot of assumptions and estimations and predictions on something we don't know. Something that's supposedly based on the end of the year figures for a corporation, although between the time you have to make that decision and the end of the year, a lot of other factors could arise. So to me, I don't see how that is a bright line. In fact, I see it just an open door for a lot of different points of view.
I think I would agree with the concern that the dollar figures sort of create the impression that someone's out there and calculating down to the nth degree whether the threshold is exceeded or not. I think it's a fair point. My response to that would be that I don't think in terms of applying these regulations, we look for mathematical precision. But the advantage of having those numbers is it gives us a sense of magnitude, the order of magnitude that we're looking for in terms of impact on a corporation. And when we're asked the question, we're going to look at that, and in probably 80 to 90% of the cases, we're going to be able to say yes or no fairly clearly, just applying common sense. And in those 20, 25, 30%, 10% of the cases where we can't, our advice is going to be cautious, and we're going to say, don't participate. And if you want to participate, what you're going to need to do is get a professional appraiser to tell you what the impact on the value of the corporation is going to be.
I guess I have a problem because you use the term common sense, and to me, the approach that's being recommended is more the common sense, reasonable person, because it's not just an actual conflict, it's the appearance of conflict.
Right.
I don't think you need to bring in experts and get to that level of questioning. If I'm an official and I'm that uncertain, I think it's pretty common sense to say I'm going to recuse myself from voting.
Right, and I would
So,
agree.
I mean, I think that it's pretty standard. It's kind of what's used for judges. It's a pretty broad understanding of if there's a possible interest, a reasonably foreseeable
Right.
effect, step out.
Right, and I would agree. Now, that's what I said, in 80 to 90% of the cases, we're going to be able to apply common sense and say, yeah, this decision, $1,000 purchase from Apple, isn't going to materially impact Apple. So if you've got a $2,000 investment in Apple stock, common sense is going to tell you it's not going to be material. Which
So
is
is
what
your
the statute's
concern
going
on
to.
those very low cases where there would be no financial effect? Is that the point of that 2,000?
It sounds to me like that is the issue, that Sean Eskovitz. It sounds to me, and I'm sympathetic to this, that the numerical thresholds or baselines were providing some guidance to be able to find, if not exactly safe harbors, safe incidents where you're not coming close to the line, and you kind of know that. I mean, I agree with you. I agree with the chair that we don't want people even coming up close to the line, but it sounds like the numerical thresholds were providing some guidance for maybe the vast majority of cases, or a large number of cases where the impacts were kind of obviously minimal.
Well, I have two responses to that, if I can.
Sure.
Number one, I think when we're talking about the minimal impact, the threshold issue there is the $2,000 investment. You don't even get into this analysis unless you have a minimum $2,000 investment. Now, I think if we're starting to say, well, these kind of small investments shouldn't really be impacted, that's an issue for the legislature because they set the 2,000. I would not dispute that perhaps it should be 5,000 or 10,000, but that's not for us to determine. So that's the first threshold. But then once you get into it, and the concern about a reasonable person would say, there is no way that my $2,000 investment or my decision on a $1,000 contract is going to impact Apple's stock. Okay, but we do have the catch-all exemption, as I'll remind everyone, in 18705 subdivision C, which says that you're always able, despite the fact that there appears to be a conflict under any of the other standards, if you can prove there is no financial effect, you're not disqualified. So there is the catch-all exception. And I think that goes to this issue we're concerned about. Are we hitting everybody under the tent? And I think there's the out. So
yeah, I mean, going to that point, I think the second point I find interesting, and I wanted to hear a comment on it from the speaker, because I mean, to me, the $2,000, I understand the legislature has spoken to the $2,000 amount, but there are plenty of circumstances where you would exceed the $2,000 amount and have non-existent impacts. So, but with respect to the catch-all, why isn't that sufficient to protect against the interest that you're flagging here?
Let me get to that regulation. And the fact that I'm using this technology is a minor miracle, given the fact I'm a dinosaur when it comes to these things. So that was
18705 subdivision C. And it applies to all the issues of determining materiality, whether it's source of income, gift, real property, or business entity.
Mm-hmm.
Do you want me to read it?
Yeah.
No, I've got it now.
You got it? Okay.
Well, that certainly gives us something to look to address that situation. It is confusing to me that we had similar language in 18705.1 that we're now taking out because there was the ability to rebut the presumption of material impact in every case.
Well, I would say, from my point of view of drafting, it started to become redundant to have to put the exception in every materiality standard as opposed to have it in the front end when we're going to say this exception applies to all issues of materiality. So that may be my fault.
Right.
If you don't like it.
No, I think it's a good point. It's a fair point. So let me get back to my other comments. So and the next comment was about the elimination of the large corporation exception from the purchasing decisions. Again, there used to be a $25,000 investment threshold, and our concern was that by eliminating that, we would have the situation where, again, the Apple example applies, and I suppose your argument with respect to the application of 18705 would address that situation as well. I
You
guess
anticipated my comment on that one.
I guess the one concern about 18705 is, now I have to go back and find it. Is it a 1 penny rule?
If you want, I'll address that.
Yeah, why don't you address that?
No, and then that's what's interesting about the comment here. Before there specifically said in the regulation that we're changing that you can rebut the presumption in the regs that led up to this. But the presumption was 1 penny, and there has never been a rebuttal of the 1 penny presumption for a business entity. The only time we've ever had a rebuttal of the 1 penny presumption was for real estate, where someone hired an appraiser basically to do what appraisers do and convince the judge that there would be no 1 penny event. But that was for real estate and by hiring an appraiser. We haven't had that situation come up with business entities. We are, as we've said over and over again, moving away from the 1 penny rule because it's ridiculous. So there would be no 1 penny rule anymore. It would be more of a recognizable or noticeable effect. So, and the presumption is still there. So actually the presumption is going to be easier to rebut now than it was before.
Well, I guess I'm confused because 18705C says no financial impact, which sounds like the 1 penny rule.
Well, we never said 1 penny rule in any regulation. That was developed from a staff advice letter and just multiplied out of hand.
Which is not the law.
And we've said over and over again that we're not going to use the 1 penny rule anymore, that 1 penny rule does not exist. So the 1 penny rule does not exist. It will not show up in an advice letter again. When we get back to getting this whole plan implemented, we can add the word noticeable or recognizable or whatever.
Well, if we deem it's
in that one.
necessary, and that's what I was going to suggest. You know, this is an ongoing project. This is just another piece in the materiality. I hope that this exception addressed your biggest concern, which I think was a valid concern, but in light of this, to the extent you think there's still a problem with the existing law, an issue that's not before us right now, I think we should address that at the next time. We're going to be back here in January with more issues on conflicts.
Great.
So I think if you could work with Bill on that and see if there's something we can do, if you believe there actually is still a problem on this issue. Does that sound like a fair approach at this time?
Absolutely. I enjoy working with Bill. We worked on several regulations together, and he knows my number and I know his.
Okay, good.
It's Commissioner Eskowitz. I think this has been a very helpful exchange, and I appreciate it. I guess I would say on that, to the extent you feel strongly that this is something that needs to be addressed, I would do it as soon as possible because this is kind of a robust issue given the materiality standards application in so many different places.
I agree, Commissioner, and that's why our goal is to bring the next and hopefully almost final set of conflict regulations to the full commission in January.
The full set of materiality conflict.
Materiality
regulations.
conflict.
Yes. Yeah, great.
Okay, so we'll address that.
That's great. And as a preview, I think I'll be looking to Bill to have a conversation about that no impact language on 18705. Maybe we can get that
Okay.
revised.
I look forward to the result.
Let me see my last comment. This is a recommendation that is based upon the assumption, or if the commission is to adopt the proposal from staff, propose language to make it read a little bit better, and in terms of applying the language, and to address something I don't think was intended, especially given our last our conversation we just concluded. If you were to look at, and I apologize that I did not put this in my letter.
It's just, and I appreciate your comments. It's just difficult to try to talk about redrafting language at the meeting and or receive the comments the day before, which I'm sure you can appreciate. And that's why we have the lengthy process leading up to today.
I do appreciate that, and do regret, unfortunately, I have the city attorney's office to run as well. So, but the comment has to do, and I think that the solution is actually fairly simple. It is, if I find the proposal.
So this is an issue that was not in your letter you're looking to address, is that right?
Correct.
Okay. They also do have to keep us moving along, so I'm just wondering if it's not crucial and if it's more of a language drafting issue, if it's not something we could address as we move forward as well, if it's just a preference in language.
So I found it. It is on line 10.
What page are you on?
Page 6. And we're talking about the factors that should be considered when determining whether or not a reasonable or a prudent person would find that it's reasonably foreseeable that the decision will have a material effect on the effect on the value of the company or the price of its stock. It says examples of decisions that may be applicable include those that, and has a list of factors. And I would suggest language to the effect that factors to be considered in making this determination include the degree to which, then you go to those factors. Because these factors can be read as saying any increase in the need for a product will then result in an increase in the price of the stock or the value of the company, and I don't think that's what is intended.
I guess I wouldn't read it that way. Again, in light of the section in its entirety, using both the prudent person, reasonably foreseeable, there are already enough qualifiers. I'm not sure we need another qualifier on this. But Bill, do you have comments?
No, I would agree with you. I don't like to get too wordy if you don't have to.
Okay. Any other comments or questions?
I do have, if we're going to do this, I do have.
We're not going to do
One,
this. I'm not
two
sure what you're referring to.
exceptions.
I'm just taking public comment right now. And if there's no more public comment, we're going to move on.
Okay.
All right. Thank you. We have another.
Thank you.
Thank
Thanks,
you.
Sean.
Good morning, Commissioners. My name is Mark Morodomi. Although I currently work at the University of California, I want to speak from my experience as a former FPC staffer and actually working as a deputy at the City of Oakland. On this regular,
I just want to be clear. So you're here on your personal,
No, I
in
work-
your personal capacity?
no, I'm here on behalf at the university.
Okay.
But I can speak. I've been doing this for like 30 years, so I can add to that experience. I want to talk about guidance and evidence. Since this regulation is a sea change from the earlier regulation, it does nullify the existing advice letters and enforcement decisions that we use as guidance in interpreting the business materiality regulation. So it's important in passing this regulation that we get guidance on what kind of evidence a public official or attorney advisors like myself and the city attorneys can draw on to establish the the standard here. To give you a little bit of context, Mr. Mason already spoke to this. You know, the city attorneys are like little legal divisions throughout the state, giving advice to public officials, and oftentimes we're under the gun in a meeting of 100 people when we're asked these advice questions. And it's not enough for us to say, well, it depends, or to give an unequivocal answer, because our clients want to know what the answer is, particularly in light of the fact that they're often accused of being in a conflict of interest of a situation from their opponents. So they need our advice to say clearly, based on the regulation, whether there is a conflict or not. On the other hand, to tell them, gee, if you're not sure, just recuse yourself. It's not that easy, because, for example, in Oakland, you have district elections. So if a city council member recuses himself, that's 55,000 people that don't have a say in that vote. The regulation applies to staff members too. So if a staff member has to recuse himself, then there's certainly an area of expertise that the city loses, or we might have to hire a consultant to fill in that space. So there are costs to that. So I want to speak specifically toward Section B, the provision that talks about the prudent investor. And the question is, when we're under the gun and have to answer the question to the city official or the university official, what evidence do we need to collect to give an unequivocal answer to what the prudent investor will do? Invariably, after the vote or after our employee gives us advice, the stock's going to change, right? And how does that public official, staff, or council member protect himself from the accusation by the press or the opponents? And I have some examples of.
Well, before you give us those examples,
Sure.
I guess I'm just having difficulty understanding how that would be any different than under the existing regulation. What evidence do you gather for the existing regulation where you need to make a prediction as to a set amount out in the future?
Sure. So the examples I have that have occurred in Oakland involve big box retail, nuclear free zone, a boycott against Arizona, fighting against predatory lending. So big box retail, right? There was an ordinance to ban all big box retail in Oakland. So in this particular instance, the staff member had investments in Costco, right? And looked up on the internet how much one Costco store, what the amount of revenue would come in from that one Costco store, and then looked at the regulation and said, well, the revenue in that case met the materiality standard, and therefore that person recused themselves. So that is one of the benefits of having the dollar standard. All I'm asking is, as you pass this regulation, help us, give us guidance. There's the nuclear free zone, cause for divestment in nuclear industries. If a member has a stock in a corporation and the city decides to divest, well, does that affect, how does that affect the value? There's the desire that Oakland will be the first and will cause a groundswell of other nuclear free zone ordinances. So how do we as advisors, what evidence do we collect? What evidence will be good enough when Gary comes knocking on the door to say, hey, we looked at this, we decided it wasn't material, on the big box retail.
But I guess to that, you're a lawyer?
Yes.
So we said, yeah. The reasonable person standard is pretty common. It's the same standard used day in and day out in the courts. And what you have to show is what is sufficient for a reasonable person to believe. I guess I'm just confused about your concerns. But as to your bigger issue on you'll need guidance, that is why we have staff. And that is why we have an advice line. And that's why you can ask for an advice letter. I understand. I don't see the same concerns you do as to the new regulation, but to the extent there are concerns and people do not understand how it's going to be interpreted. That is why we do have.
And I get that. We've taken advantage of that. It's just that these decisions and issues come every day. We for any one of these issues, there's 20 kind of policy decisions. So we are under the gun and have to collect evidence and make a decision on the spot. So that's why when you adopt a new regulation or a new standard, just setting out the rule isn't enough. We need more embellishment based on what the history of the other regulation was.
Okay. Any other questions or comments? Okay, hearing none, I will move to adopt item 53.
And I'll second it.
Commissioner Kasher,
Yes.
Commissioner Eskovitz,
Yes.
Commissioner Wasserman,
Yes.
Commissioner Nguyen,
Yes.
Chair Remke.
Yes.
This motion passes.
Okay, thank you, everyone, and thank you for your comments. They're definitely helpful. And again, as we proceed, we'll continue to look forward to hearing from you. All right, I think the last.
Chair Remke, I just wanted to note, Commissioner Nguyen had a question on one of the staff reports and I think Gary was going to address it.
Okay, let's go ahead. Because we're up to the staff reports now. So if there are any questions, and Commissioner Nguyen, go ahead.
Thanks very much. Well, the staff did a good job just piquing my interest in an enforcement case. And it was the Aldo Flores. So this is in the litigation report. And it said that there was an order to show cause hearing on November 7th. And my question is, what happened?
We wanted to leave a little drama for you. So
Yeah, drum roll.
it's super exciting. There was a continuance. I wish I had more exciting things to tell you about it, but I honestly don't recall the day off the top of my head, so I apologize. But I will get you a specific date, and obviously next hearing we'll have the update as well. So.
We always say a continuance is as good as a win. It just doesn't last as long.
All right, if there aren't any other comments or questions regarding the staff report, those will be submitted. Okay, are there any other comments from the commissioners? All right, I move to adjourn the meeting.
I'll second.
Commissioner Kasher,
Yes.
Commissioner Eskovitz,
Yes.
Commissioner Wasserman,
Yes.
Commissioner Nguyen,
Yes.
Chair Remke.
Yes, thank you.
Thank you.